Hi, Carolyn Duncan here, Duncan Legal. Today we're going to talk about family law and mediation and what you need to do to kind of get ready for it. So when is mediation required? My family law practice is in the Metro Denver area, so I do Arapahoe, Douglas, Denver, and Jefferson County. In Arapahoe, Douglas, and Arapahoe, mediation is required, and when we get that first case management order, it's going to tell us what is our time frame to get mediation completed. Jefferson County, it's not in the case management order, but the moment you set something for a hearing, whether it's temporary orders or permanent orders, they backdoor it. All of a sudden, there comes the mediation order that says you must complete mediation before you can have a hearing on your case. So when is mediation required? Well, depending on what county you're in. I practice in the Denver metro area, so that's Douglas, Arapahoe, Jefferson, and Denver. If your case is filed in Douglas, Arapahoe, or Denver County, it's going to be in the case management order. They're going to tell us the timeline of when we have to complete mediation. If it's in Jefferson County, they don't include it in their case management order, but as soon as we set a matter for hearing, we get an order to mediate. So whether you're going to temporary orders or you're going to permanent orders, in any of these counties, you must attend mediation first. So what is mediation? Mediation is when you have a third party who's not related to the case, they're very neutral, in which they're trying to help you reach a compromise. We always do it in separate rooms because you don't want to face down your adversary. So if you're the petitioner, you usually go first, where the mediator comes in and says, what are the issues that we're trying to resolve today? And then they'll go into the other room and they will put your proposal in front of the respondent, the other party. And it goes back and forth between the two rooms. Rarely will the parties to the divorce come together in the same room. Sometimes the attorneys meet in a separate room to discuss things, but not that often. Mediation can be a wonderful tool, and it's usually less expensive than actually going to a hearing or going to trial, which takes a lot of preparation and time. But in order to prepare for your mediation, you need to make a list of, if I got everything I wanted, what is it that I want? So you need to talk about the assets, the division of the debts, the retirement, maintenance, children, all of these issues. And you put it into categories. So the first one, you're going to say, this is my ultimate wish list. The second category is, hey, I really don't care that much about that item, so it's a throwaway if they don't want to agree to it. And then you have the, gosh, this really means a lot to me, and I have very little room to compromise. You don't have to like the agreement, you have to be able to live with it. And if you can live with it, then you're on your way to a successful mediation.